Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis, Wright, and host David Lamb.
Hello and welcome into the attorneys. Thank you so much for joining us tonight. We've got a really interesting show that we believe will be of interest, particularly to you. That's kind of why we put these shows together, in hopes of that. A couple of reminders in case this is your first time with us. You'll see information at the bottom of your screen how you can communicate with us. We'd love to hear from you. Also, Hollis Wright makes available each and every Sunday evening during this show attorneys ready to take your call. So the opportunity for some free, all fair, confidential legal advice. Take advantage of that. Could be the subject matter we're talking about tonight or not. If you get a question and need an answer from an actual attorney, one from Hollis Wright is standing by during the show. Leading our conversation, he's the managing partner of Hollis Wright, Josh Wright. Good to see you, sir.
Good to see you, my friend. How are you?
I'm doing all right. How are you?
Another good week. We made it through the week, and it's Sunday night.
And that's always a good sign, isn't it?
No questions.
We ready to dive in?
We're ready to dive in. So, David, here's the deal. If you think about it, just about everybody in their family has an individual, either because of age or medical condition, Alzheimer's, strokes, other issues, need to consider things like a guardianship and a conservator to protect those individuals, either from themselves or from other family members, right? So we're going to be talking about that today, and some other probate-related issues, and some reasons why you'd want a guardianship and or you'd want a conservator. So it's an important topic that I think impacts the viewing audience. Anna Lane is with us today. First of all, welcome.
Thank you.
I want to hear about your practice in a minute, but let me just tell you, she works at Gelch Associates, and she does a whole host of different things. She does some personal injury work, kind of like we do, wrongful death and those things, but she also specializes and has for many years in the area of guardianships and probate work and conservators. And we're going to be talking with her about some of that stuff today. So first of all, thank you for being on.
Thank you for having me.
So let's talk just for a second. Now, if you do, and I kind of laid out what you do for a living, it's not often that you see people that are as multifaceted as you to be able to do guardianship and probate and conservatorship work too, in addition to the other things. How did you get into that?
Well, I was kind of born into it. I think after you've practiced law for 17 years, sometimes it takes a moment to discover what fits you the best. And oftentimes in the law, we get weighed down with things that are burdensome and that we take home with us. And one benefit to probate law is it's usually very helpful to a family, whether you're doing an adoption, whether it's a commitment, or getting a guardian or conservator for a loved one. It's a happy court is the kind of the way I describe it, because you can really reach out and you can grab hold and you can help a family through a very trying time. And oftentimes as attorneys, we sometimes don't get to do that. We have the black, the white, we're on different sides of things. And this court oftentimes helps us come together and do what's best for our family member or our loved one.
Positive way to look at that. Now, do you see this a lot of times, the conservator, the guardian? Do you see it in contexts where someone gets of an elderly age and requires that? Is that what you see most often in your practice, or do you see it more in commitments? Because I know you do some commitments too.
Well, both.
Okay.
I think most families tend to begin this process when a loved one becomes older. So we see it a lot of times in the elder law. Have you prepared for these types of things or have you not? Because you can prepare for these things to make the process a little bit easier, and we can talk about that in a moment. But primarily, if you don't have a durable power of attorney ready, then when your loved one gets older, your grandmother, your mother or father, and they start to, let's say, have dementia or the early onset Alzheimer's, or let's say they have a stroke, or they have a heart attack. Maybe it's just a temporary condition that will resolve itself. The court is prepared for all of those things.
Well, and what is it you mentioned, and I know we've talked about it a lot on shows, durable power of attorney. How does that help a family member? How does that help?
It helps, the best way that it helps is it gives their wishes prior to them becoming incapacitated. A lot of people believe that when you go and you're approaching the issue of, do I need a guardian or conservator for my family member, The question, they're like, oh, well, why can't we just have a power of attorney? People believe that a power of attorney rules all. Well, it's great and wonderful if you are not incapacitated at the time that you execute the durable power of attorney. Unfortunately, many people don't want to give up their rights and give up their property or give up the ability to make these transactions prior to something happening, so many families are unprepared for what happens.
So if something happens to a family member and you need to set up a guardianship or a conservator, what's the difference between those two? Because I know sometimes lawyers that aren't super educated in that area, they look at them kind of as the same thing, but what's kind of the difference between the two?
The main difference is that in a guardianship, it means that you need someone to take care of your day-to-day activities, and it's non-monetary typically. Maybe you need to set up in-home nursing, maybe you need to put your loved one in a nursing home. A conservatorship primarily means you're taking care of their money. And that is the main difference. Are you taking care of their health care, or are you taking care of their money? And that's the main difference.
Relative to, these are kind of tough decisions for a family to make.
Absolutely.
Oftentimes. When do you advise these conversations taking place? Because it almost seems like whenever you have to do it, that may be a little too late. I mean, do you advise kind of being proactive on these discussions?
Absolutely. Any time that you can be proactive and you can get that durable power of attorney prior to them becoming incapacitated, it makes it a dream. You just follow the rules that they've set out and it works wonderfully. Unfortunately, when you have to go through the court, there are very specific requirements. Right. And one of the requirements that can be most difficult is obtaining that doctor's letter. The doctor's letter that says this person can no longer take care of their personal affairs. Oftentimes, you can't convince them to go to the doctor because they don't believe that there's something wrong with them. So that can be trying, but if you've pre-planned and you can help your loved one understand that you're not trying to take anything from them at this point, and you have that trust in your family, it's much better for the family to have pre-prepared for this. Unfortunately, if you have an auto accident, for example, and you immediately become incapacitated from a head trauma or something like that, you can't prepare for something like that.
I know we're getting ready to go to break. When we come back, I want to talk about, because I think Anna's laid the foundation, how do you actually go about this? Like, what are the steps you take to go set a guardianship or conservatorship up? And let's walk our way through that, because I think that'll be important.
I agree. All right, we'll pick up right there. We're heading to our first break. As we do so, a reminder, Hollis Wright, very active on social media, Facebook, Twitter, as well as Instagram. If you search Hollis Wright, use it as a great informational, educational tool. Certainly a follow you're going to want to take note of there on social media. Check out Hollis Wright. Again, Facebook, Twitter, and Instagram. Stay tuned. We're coming right back.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Welcome back into The Attorneys. Appreciate you being with us. Before we head back into our conversation between Josh and Anna, just a reminder, attorneys from Hollis Wright standing by all throughout the show, ready to take your call, so take advantage of that. Josh?
All right, so when we went to break, I wanted to talk a little bit about the steps associated with setting one of these up, but let me just ask you a general question, kind of a high-level question. When does a court generally appoint a guardian versus a conservator? Because I think giving some context to those watching will help explain when one thing works versus the other, and maybe some examples will help us.
Certainly. An example always helps me relate to the client when you're speaking with them about what to do. For example, where a conservator is not needed, but a guardian is. Let's say John has been in an auto accident, and we represent him on a personal injury matter, and there's a settlement that comes in. Maybe he lives in his parents' basement. He can walk around town. He can handle most day-to-day activities. He can shower. He can take care of himself. But he has no ability to do math because he's got a brain injury. And so without his ability to handle his finances, he would need a conservator, but not a guardian, because he can take care of his day-to-day needs.
All right, and then then in circumstances where you would just need a guardian, that generally is going to be non-monetary related
Non-monetary.
issues.
Let's say you have a client and they have suffered a stroke and they can no longer move certain body parts and they need to be placed in a nursing home, but they have no income other than Social Security. You would only need a guardian to make their health care choices, as opposed to a conservator to handle their finances, because a conservator is not necessary if you only have Social Security benefits.
Yeah, so that is perfect.
Helpful.
Examples always help me, there's no question.
A question we've got here: what are the steps followed in appointing a guardian or a conservator for an adult?
Okay, well, they're very similar with one main difference. You would file a petition with the court, obviously. The court would appoint what is called a guardian ad litem. And for those that don't know, a guardian ad litem is a person that is appointed to represent the best interest of the party. So the person that you are trying to get the guardianship or conservatorship for, that person would be appointed only for their best interest. The difference in that in an attorney is an attorney has to do, we give advice and we have to do what our client tells us to do. Right. A guardian ad litem does not. They do what's in the best interest of the party, because that party may not be able to make a good decision for themselves based on our advice.
So we get this question a lot when we talk about guardianships. Why would, for a guardianship or a conservatorship, why would a bond be required?
Okay, a bond is only required if you want to be a conservator.
Okay.
The bond, very simply put, is to protect the assets of the ward. Once the person is deemed incapacitated, they're termed a ward. The conservator is in control of their money. It may be $50,000, it may be $100,000, it may be $1 million. And so the only purpose of the bond is if the money is misspent or lost, because when you are the conservator, you have to report to the court. You have to explain what you're spending the money on, how you're spending the money, and the bond is simply, you can go to State Farm, you can go to any insurance company, and they will provide a bond if you qualify, and they have their own qualifying terms, for the amount of the money, so that in case that money is misspent or lost, that the person, the ward, does not suffer any negative side effects of someone mispurposing their funds.
And so basically it's insurance for the conservator to make sure that they're doing the right thing and protects that individual if something goes wrong.
Can the court appoint both the conservator and a guardian as well?
Yes.
Can it be the same person?
Yes.
Really?
It can also be different people.
Yeah.
Mm-hmm.
What about this? Because I know there's going to be somebody sitting on the couch right now saying, man, I really think this sounds like something that we need for my mother, my father, but I know my siblings don't want to give control up to some third party. Can a family member serve in the role as a conservator?
Absolutely.
Okay.
The court actually prefers a family member or loved one to be involved in this, especially as the guardian. They do have a county conservator if you can't agree on a conservator. However, if the family member can act as a guardian and conservator, there are no fees associated. If you have money held by the county conservator or any conservator, there are fees associated with that. And so often oftentimes it's the best way to preserve the assets of the individual.
So, sometimes with these decisions, if it's a family member, it's kind of hard for them to not be emotionally, and the emotions kind of can get into what really is the best decision. It just muddies that, because it's so difficult. So are there times where maybe an attorney or some friend might be the better choice?
Absolutely, and the judge would make that decision. And oftentimes that is the case. Some family members don't want to be put in a position. Let's say you have a family member or a loved one on a ventilator, and you have to make the decision to turn it off. Oftentimes it's better for that to not be someone that is so emotionally attached.
And let's also talk about this. In circumstances where there's a conservator set up that may not be part of the family, that conservator, do they have oversight? Like, are they overseen by the court if they make distributions, so that a family member who has a third-party, non-family member conservator can rest assured not only are they bonded, but they're responsible for going to the court for certain expenditures? Is that fair?
They are required to report to the court.
Okay.
It is a requirement as the conservator, whether it's a family member or not. They are required to report to the court. And that is one of the things that people need to consider when they are engaging into becoming a guardian or conservator. You really need to think about it, because this is a lifelong obligation most of the time. And you have to make very difficult decisions, and you have the family workings. If you have siblings, if you have brothers, sisters, aunts, uncles that have strong opinions, you need to consider how that interaction is going to take place.
Yeah, I mean, sometimes having a third party involved is not a bad thing, especially if there's not complete alliance between the siblings. Not in a bad way, but sometimes the siblings may have different approaches as to how they think so-and-so should be managed and handled. Having a third party in there that has court oversight is a good example. The good thing about this is you don't want to try and go this alone. You want to go to someone like Anna or others that do this type of work, because they can lead, guide, and direct you through the process. I mean, for example, you do initial consultations just to advise people, do you not?
Absolutely, at no charge. So you can come and you can get an appointment. We can sit down. We can go over. You can bring your whole family, and we can talk about these things. You can bring the loved one with you. That if you're preparing for things that could go wrong, like you're preparing for something that could happen to an elderly loved one. Let's say your grandmother's 80, and you want to make sure. For my grandmother, we set up a dual power of attorney so that we didn't have to go through this process with her.
You mentioned also the county conservator. What role does the county conservator play? Do they generally step in circumstances where maybe a family can't agree on somebody, or can you get any third party to be a conservator if the court will approve them?
Any person that the court will approve, if the judge were to determine, for example, we have brothers and sisters frequently that cannot make a decision on even who the guardian should be. Or, the judge will say, okay, well, if you can't agree on someone and you don't have someone chosen, then let's do the county conservator. It is, I think, a little bit more fiscally responsible than some of the private holders.
When we come back, because I know we're getting ready to go to break, when we come back I want to talk a little bit about just the interplay with families and how they work with their loved ones to get these things set up to protect their interests moving forward, because I think this really is, as Anna mentioned earlier, it can be a happy court, because ultimately it is at a place where people love somebody and they want to help protect them. So we'll talk through that.
That's right. Best. All right. We're stepping aside. This is our final break of the evening. As we head to break, a reminder, if you want to join the conversation, here's how you can do that. Stay tuned. More of The Attorneys coming right up.
I'm Josh Wright with the law firm of Hollis, Wright. As with any industry, it's important in the legal world to hire an attorney that is knowledgeable and has a track record of success. But with so many attorneys out there and so many different types of cases, how does someone decide the right lawyer to hire? In this week's Legal 4-in-1, we're answering the question, what should I consider in hiring an attorney? In-state versus out-of-state, big firm or little firm, recommendations from friends or family, the internet, the phone book, or TV. With so many choices and so much information, it can be an overwhelming task trying to make the right decision. To complicate things, choosing a lawyer is an important and sometimes life-affecting decision, and should not be taken lightly. So how do you select an attorney? First, do your research. Look the firm up on the internet. Learn about the cases they handle and the results they get. Second, find out what clients are saying about the firm. Many websites provide client testimonials or have a star ranking system. Use those to your advantage. And finally, talk with a lawyer from their office and ask them questions. Questions about the volume of cases they handle. Do they return phone calls? Are you just a number or a client that gets the attention you deserve? Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys right here on WVTM 13.
Welcome back into The Attorneys. The show is just flying by. About 7 minutes remaining, so don't forget, if you want to take advantage of that opportunity to speak with an attorney from Hollis Wright, they're standing by live, that off-air confidential conversation that's also free. You got about 7 minutes left to do so. Josh?
Calls, texts, and emails. We do all those. We respond to all those each time. We try to do a good job of that.
Y'all do a great job of it.
Well, we appreciate the opportunity to help answer questions on stuff like this. All right, Anna, talk to me about this. It would seem to me, in the world that you live in when you're dealing with a conservator or a guardian, that they oftentimes can be used to align families that may not be getting along so well. For example, if you appoint a guardian can make some decisions that would have caused conflict between siblings, which sometimes will happen, right? Siblings don't always see eye to eye. And do you see that? I mean, is this sometimes a good thing to do for a family in order to protect the sibling relationship?
It is, and I'll tell you, for example, I was involved. I was actually the guardian ad litem for an elderly woman, and one of the siblings did not believe that she had any deficiencies, and they lived out of state. The other sibling lives right down the street, was coming in daily, would see the stove left on, would see things that were very alarming for her mother. We had a very difficult time because there was nothing set in place. They had no plans. She developed dementia, which was Alzheimer's, and it was very difficult. It wound up where the judge actually had to finally make the decision because the siblings could not even agree that loved one was ill.
Terrible. All right, we've got a question here. Time is flying by, so I want to get this one in, and I need my peepers to see this here. How long does the guardianship or conservatorship order actually last?
Well, it lasts until the ward has passed away, or until the judge makes a different decision. So someone could petition the court and say that the guardian or the conservator were acting inappropriately. Maybe they had misspent some funds. It can be brought before the court for those reasons. If the conservator or guardian dies, or they can resign, which is also also has to go back before the court. But sometimes you don't think about the guardian or the conservator passing, or them having some tragic accident as well. Or if the court finds that it's in the best interest of the ward to remove that guardian or conservator.
What's the interplay between the topic we're addressing and involuntary commitments?
Okay.
Somebody has a mental deficiency and needs to be involuntarily committed for a period of time.
Certainly.
What's the interplay between those two? Because we get a lot of questions about this of, hey, I need to involuntarily commit a family member for the following reasons, they're having issues, whatever. and they want to know what the process is, and how do these two things interplay with each other?
Okay. Well, one thing I also wanted to mention when the termination can occur is also if the court finds that the ward is no longer incapacitated, and that also works. That blends right in with involuntary commitments. Involuntary commitments, a person can be involuntary committed for several reasons. Frequently, the person is mentally ill. Maybe they're schizophrenic, bipolar, and it's a lifelong illness. And so those are things that but just because that you're bipolar or schizophrenic and may not be able to manage your day-to-day living, it depends on the level of the disease and the treatment. If you're taking your medicine most of the time, you don't typically have problems. But a lot of times, an involuntary commitment can also be used when you're looking at a guardianship or conservatorship. The main deciding factor is the doctor's opinion, the doctor's letter that the doctor must write to the court, that the judge can rule on whether or not that person is incapacitated. If you do not have a doctor's letter agreeing with the court or agreeing with the petitioning party that this person has dementia or has Alzheimer's or can't take care of themselves, then the guardianship and conservatorship cannot go forward. So sometimes an involuntary commitment is filed so that they can get them to the hospital because the individual refuses to go to the doctor. They don't believe that there's anything wrong with them. So an involuntary commitment can be used to put them to put them into the hospital to get that evaluation so that the court can obtain what it needs to move forward with a guardianship or conservatorship.
If that happens, the individuals that are in that involuntary commitment, they also have rights too, do they not?
Absolutely. They are represented. They have their own guardian ad litem. There is a separate hearing. There is an attorney that presents the petition on behalf of the petitioner, appointed by the court. In an involuntary commitment, there's really no cost. There's not typically a filing fee or anything like that, because it's just to help a person that is out there.
Less than 2 minutes remaining. Time enough just for a final thought from the both of you. And if you would, you go first, please.
My final thought would just be try to plan ahead. If you can, sit down, talk with your loved ones, especially the ones getting up in years, not to take their rights away, but any pre-planning that you can do, even if you can obtain that durable power of attorney, if you can meet with your siblings, meet with the sisters, the brothers, the aunts, the uncles, and sit down and express to them what your wishes are.
Right.
If something were to happen, meet with an attorney. Don't try to do this by yourself. Yeah. And consultations are free, so go sit down, meet with an attorney, meet with me, meet with someone else. Right. Just get some advice so that you're not out there alone.
Right.
Yeah, I would just say plan. The key to all this is plan. It's easier for people to be aligned with one another when you have a plan and you have a purpose and you're on an agenda, right? So plan ahead. Meeting with somebody for an initial consultation like Anna is a great example with her firm to be able to go through that process, and then you can be led, guided, and directed in the right way where everybody's on the same plan, same agenda to try and eliminate some of the conflict as folks get older.
Have those
Great job,
tough
by the way.
conversations.
Thank you.
Great
Thanks
job.
for having me.
Thanks so much. Thank you for joining us as well. We appreciate it each and every week. We'll look for you next time right here on The Attorney.
Thanks for watching The Attorneys, sponsored by Hollis Wright.